Stanislas, who is professor at the Royal Military School, a federal institution, and students Victor, Charlotte, Slieve, and Nathalie, who have also been so kind as to reserve some of their time for our speaker at the weekly research gathering, Dr. Marie-Sophie SILAN. I will briefly introduce our guest and then, of course, the team that she's going to address. Now, Marie-Sophie SILAN is a doctor of the University of Liège. She prepared a PhD dissertation under the supervision of Professor Jean-François Jerkens, who is not unknown to many people in the room. Professor Jerkens is a specialist of Roman law, but also of comparative law. Is very active internationally, among others in the Société de Vichères pour l'histoire des droits de l'Antiquité. Is originally German-speaking and perfectly trilingual, Dutch, French, Belgian, which makes him one of the most illustrious subjects of His Majesty the King of the Belgians in the field of legal history. The dissertation of Ms. SILAN was started in 2020 and was completed in 2024. She worked as a PhD fellow, so aspirant of the FNRS, which is the FBO of the French-speaking community of Belgium. Jean-François Jerkens is currently in Napoli in sabbatical, and his courses are being taught, and it's quite a lot. So it's quite a serious responsibility, among others, by Madame SILAN. That's a bit of the framework. Some of you might have seen in the Teams chat feed that I posted an article of her in the Tijdschrift voor Rechtsgeschiedenis, Revue d'Histoire de Droit and the Legal History Review, which is a journal of reference for legal historians in Belgium and the Netherlands on the Web of Science. Her dissertation will be published in English to be accessible to the broadest possible audience, among others, the Netherlands, Germany, Italy, Japan, China, Argentina, Brazil, Chile, etc. Please. Hello, Oscar, kom maar binnen. After presenting our speaker, anders als als je daar zit, ga je niet meer. Ja. The team. I advertised gender and legal history, and of course, to people living in 2025, gender is quite a large concept. Prior to the election of Donald Trump for Facebook, there were 58 genders with which somebody could identify. Of course, this is not how things worked in the early modern periods, but all history is contemporary history in the sense that successive generations of historians and also legal historians can interpret and reassess sources of which they thought that everything had already been said. And when I was going through our speaker's article in the TRG again, I was struck by the fact that she mentioned our illustrious predecessor, John Gillissen. John Gillissen was a professor of legal history at the VUB and the ULB. Did his PhD in the 1930s under Bonenfant, professor of medieval history at the ULB, and then started to teach after the Second World War, basically on everything in legal history at both institutions. Behind Oscar and Antoine, there is a series of the publications of the Société Jean Bodin pour l'histoire comparée des institutions, a kind of world legal history association that held conferences on generic themes that are still quite today. L'enfant, the child, les grands escales, so the big commercial networks, les sûretés personnelles, so securities invested in persons, la monocratie, gouvernement gouverné. There also is a volume on la femme, for instance. Gillissen is famous for his publications on institutional history, like on the Tijdelijk Bewind, Voorlopig Bewind, Start of Belgium in 1830, but also for what he has written on the homologation of customary law. And a lot of the topic that will be addressed by our speaker is not in ordinances or legislation, but is in unwritten customary laws that have been put into paper in the 15th, 16th, 17th century, both in France and in our regions. And this mixed type of half legislation, half custom, and also a bit of doctrine has inspired legal historians. For instance, Tamar Herzog, who was here a couple of months ago, has also devoted a lot of time to that in her general history of law in Europe. That is tradition. In the next generation at the VUB, my immediate predecessor, Martel de Metzenare, contemporary historian, worked a lot on gender history and was one of the co-founders of REA, the Interdisciplinary Center for Gender Studies at the VUB. which is at the Faculty of Social Sciences. Bartelt has worked with our voluntary collaborator Eva Schandeveld, who worked on women in the Belgian judiciary, and the first woman in the Council of State after the Second World War. So there is some tradition and some link at the VUB with this research, especially with the PhD of Kat Capelle, who defended in 2020 in September. She worked with our colleague Dave de Ruijster on the agency, so possibility to do something, of married women and widows in Antwerp in the 16th, 17th century. As you know, Antwerp is sometimes seen as the center of the world by people who inhabit it today, but it was kind of this in the 16th century as a commercial metropolis, which means that there is a lot of money, and there's a lot of money, there's a lot of law and of transactions and of deeds, of wills. And Kat delved into the archives of the notaries and the aldermen in Antwerp and worked on difficult sources, because there are students around the table here, and there's one thing you should never forget, that everything that we will hear now comes from the early modern period. In the early modern period, there is printing, of course, but not everything is in print, and the majority of sources are handwritten. Especially for the 16th, 17th century, the handwriting is very complex. So there is both a legal aspect, there's a biographical aspect, and there's a contextual aspect. We should not forget that even though our speaker today comes from Le Brabant Wallon, Liège used to be something like Canada is for the United States today, if you look at it from the Austrian Low Countries. Liège was an independent country. It was Reichsunmittelbar. The Prince Bishop of Liège only had the Empire and the Holy Roman Emperor above him, and administered his affairs as he liked. John Gillison has given exercises in the second year for the law students in the 1950s to analyze ordinances of the Prince Bishop, whether they were legislation enacted solely by the Prince Bishop or by the État. That's something that Antoine is very well versed into, the representative institutions of Liège. Liège at the time was the present province of Limburg, big parts of the province of Liège, small part of Luxembourg, of Namur, of Hainaut. It was all over the place. So it's actually past a foreign country, but Liège was actually a foreign country compared to Brabant, Flanders, and the other parts of the Spanish and Austrian Low Countries. Now, research on gender in general in legal history is flourishing, yes and no. Why? Most people make associations with things that we see as equal and equivalent today, but that used to be within the scope of criminal law before. Should not forget that adultery, so overspel, was punishable by law until 1987. So if you wanted to get a divorce, you asked the police to invade the home after 5:30 in the morning, etc. I don't know if some of you sometimes watch Eclipse TV. It's a private television station on Telenet on Digibox, mostly watched by elder people because they do things on travel and on the mass and so on, but they also give out the old BRT series Langs de Kade, the police series on the port of Antwerp. And the first season was made in 1987, and they repetitively do a sketch where they have to send the police to somebody who's in bed with a person to whom is not married. That's one aspect. The other aspect is, of course, the issue of same-sex relationships. And I bought this book a couple of years ago, edited by Norman Domeyer and Christian Lulling, Homosexualität an Hof, Praktiken und Diskurse vom Mittelalter bis heute. Last year there was a student, Lentel van Usch, who made her PhD on the two strands in historiography, in general history, that have investigated the link between criminal law and gender. On the one hand, the prosecution of homosexual relationships in Bruges, where Jonas Roelens from Ghent has done his PhD on, which is also now a popular edition in Dutch, the Verzwegen Zonde or something like that. And on the other hand, at court societies, there was a certain degree of toleration for same-sex relationships. Sometimes for political reasons. If the younger son was not too much into women, he would not be a threat to his senior brother who would inherit the throne and so on. And serious historians here have started to reinterpret sources of which some people thought that there was nothing new in them. For instance, there's a beautiful chapter here by Charlotte Becerra from Göttingen on the diaries of Archduke Charles of Austria, the future Emperor Charles VI, when he was in Spain during the War of the Spanish Succession. And she deducts from his very hard-to-read diaries that he would have had a kind of intimate relationship with one of his advisors. in a very complex religious and mental setting that differs from what we know today. So in a certain sense, historical research is always about understanding society, understanding the past. Law is one of the aspects in a very complex interaction. But we tend to revisit now things that seem to be closed off. And the chapter of Charlotte Becerra is very strong in the sense that she demonstrates where predecessors have wiped out certain parts of the source or have imposed their own moral Victorian conceptions on things that they did not want to be read or seen. And in this case, the evidence is quite compelling. But then, of course, it's criminal law. And as you all know, if you go to law school, criminal law is 90% of what you see in the newspapers, but it's 10% of what you learn in law school. Because 90% of the other business is in the other branches of the law. It's in corporate law, it's in family law, it's in private international law, I don't know what. It's mostly about money. And the possibility to administer a patrimonium, the possibility to be independent in terms of material means, is one of the key topics that we see both in older legal history scholarship, like Meijers on inheritance law, Veenstra on the reception of Roman law, etc. We have a big tradition in that. And on the other hand, in new scholarship, in the sense that we now are getting more and more aware, as with the works of Kat Capelle, that a widow, for instance, could perfectly administer a business empire in the early modern period. One of the striking examples was 2 weeks ago when I went to the Museum of the National Bank, which is for free just in the city center of Brussels, beautiful 19th century bank, completely renovated. We had in the 18th century La Veuve Nettine, a widow administering the private bank that was actually the bank of the government and that had complex financial and diplomatic relations all over Europe. It was legally possible. An unmarried woman or a widow could administer a patrimonium and pose what we call in private law dadenbandsschikking, could alienate property, could acquire new property. The big question, however, is what can a married woman do? And there, the local solutions differ starkly. You know from what you learned with colleague de Rijsse that in cities, the rules tend to be more liberal, and countryside much harsher, but there are also big differences between Vlaams, Brabant, Liège, and so on. Voilà, that's more or less the framework for the person and the team. I hope I have been correct and complete. And then it's my privilege now to withdraw to a chair and to listen to our speaker. If you have any questions for Dr. SILAN pursuant to the talk, do not hesitate to post them in the chat or to raise your hand, and we'll try to put them before her. There are more or less 45, 50 minutes to speak. Don't have to hurry. The framework is very informal. And for the students present, if there's something you don't understand, just ask or raise your hand. Okay?
Thank you so much for this introduction. And now I have to go by the next library when I exit the class because I want to go and buy all the books you discussed with them directly. Just a question for the slides. Do I have a remote or anything?
Yes, of course. Sorry. You can use the mouse. Voilà. So normally if you click here, you go to the next slide.
Right. Thank you so much. So yes, indeed, last September, I defended my PhD dissertation, so on the topic of the legal status of women in general in the former Principality of Liège, more specifically in the 16th and 17th century. And today I will, of course, only focus on one of the topics of this research because I could never talk about anything, namely the legal status of married women in particular. So my presentation will go as follows. First, I will introduce a bit more about the framework of my research. Professor Dont already introduced Liège for me. Thank you very much. I don't need to talk about it anymore. But I will show you a bit the sources I have been using to conduct my research, so you see a bit where I draw my information from. Then I will discuss the legal status of married women, and there first I will focus on the relation between women and their husbands, so really women as wives. And after that, I will focus as well on women in relationship to their children, so rather women as mothers. So I will start my presentation, it's working, amazing, with a brief introduction to my sources, the methods I resorted to. So you'll see on the next slide, this is the Principality of Liège, absolutely all over the place, like Professor Dunn described it at the time. So Liège, this episcopal principality covered by a man who is at the same time a churchman, a bishop, but also a prince, depending on the emperor of the Holy Roman Empire. So what you have there is on the right map of the Principality of Liège in 1789, so just 6 years before it was annexed by the First French Republic. And on the left, you have a picture of, a drawing rather, of the city of Liège at the time. So the city of Liège was, of course, the capital of both the Diocese of Liège and the Principality of Liège. And why do I show Liège? Because the sources I resorted to were mostly related to people who lived in Liège. So as you described earlier, a city, so a more liberal center and mindset in general, also in the law. So why was I interested in women in Liège specifically? Well, mostly because it had not been done before, or only in parts, so to say. So most contributions we had about the private law of Liège, and more specifically regarding the law of family and persons, were very focused on one aspect of the private law, namely what is called the main-lévy regime, which is, I will discuss it at length later, the matrimonial regime in Liège. So only very focused on that specific aspect. And so another problem was that most of those sources, with a few exceptions, were also quite ancient. So it was time to rediscuss a bit the sources we had. And lastly, one of the big problems with those sources is that those contributions is that almost none of them took into consideration deeds from legal practice, or only in a very limited amount, such as marriage contracts and last wills, which are the sources I focused on during my research. And why are those sources important? Well, legal historians, including Godin already in the 80s, had suspicions that private deeds were often used by individuals in the early modern period in order to modify or even completely derogate from the customary matrimonial regime, with, of course, significant implications for women. So this is something I really wanted to explore. So my ambition was to write a monography that would both analyze the customary law sources and also bits the statute law sources, which had already been studied by other legal historians. Of course, John Jellison in the 60s and 62 in this volume you mentioned about La Femme in the series of the Société Jean Baudin. So basically more this approach on the what we call the law on the books, the formal law, the written law, the established law, so to say. And I wanted to also study deeds from legal practice to compare simply the provisions from legal practice with what the formal law was describing regarding women. So there was more following what we call a law in action approach. So a bit more on the sources I studied. So first I used printed sources, starting with this one. So this is the so-called Recueil des droits marqués pour coutume du pays de Liège, written by a lawyer called Pierre de Méan in the first half of the 17th century. So basically, this is a compilation of the customs of Liège from that time. Pierre de Méan was an alderman of the city of Liège, namely a judge, and he was also a very recognized lawyer. So he was also the father of another, even more famous, important lawyer, a man named Charles de Méan. I will mention his opinions about the law of Liège several times during this presentation. One thing to know about the Recueil des droits marqués by Pierre de Méan is that the text originally was ordered by the Prince Bishop of Liège, and so it was meant to become statute law, so to be passed as an official ordinance. But one or several, it's not very clear from the archives that we have, one of several of the États liégeois, so representing the three orders of society, opposed the publication of this compilation. So it never received the status of an official law, an official ordinance, but unofficially, it was always recognized and used as such by both legal scholars and legal practitioners. Other printed sources I used included, for instance, legal ordinances issued by the Prince Bishop and his closest advisors. Also consulted a few regulations issued by trade guilds from the city of Liège. And also, of course, what I call legal literature, namely comments on the law of Liège written by the most important lawyers of the time, such as the famous Charles de Méan, or someone like Vincent de la Hamède, or Dominique François de Saué, also a very famous lawyer from Liège, but who wrote a bit later on in the 18th century, but wrote a lot about the law of Liège. So besides those very legal sources, I also resorted to some non-legal sources because I wanted to provide a bit of a complement and to learn more about the context of those legal sources. So, for example, I used moral or household economy treaties, like those two, and also a couple handbooks for confessors and priests, very important literature at the time that discussed a lot, of course, the private and most intimate matters of parishioners in Liège. So regarding manuscript sources now, I focused my attention on especially one set of archives, namely the last wills, testaments, and marriage contracts drafted by inhabitants of the city of Liège. Last wills and marriage contracts, which made their way to us today because they have been preserved, recorded, and then preserved by the Court of Aldermen of Liège. So the Court of Aldermen of Liège was basically the principality's most powerful civil and criminal court at the time.
The two keys on the slide, are they papal or?
I'm not sure what they are.
The bishop?
I think the two keys, aren't they? So this is the symbol of the notary that wrote the document. That's an original minute of a marriage contract.
Okay.
And you can also see it because the document has been folded. So very likely the notary, after writing it, folded it and put it in his pocket or in his bag or something. And that is its official sign. Mm-hmm. So this one is not a document that has been recorded as such by the Court of Aldermen, but I put it there to show what the original documents, the original minutes of the notaries looked like, and not just the copies made by the court. So yeah, that's a marriage contract drafted in the 16th century in Liège that I found in the archives of one of the notaries of Liège at the time. So for the 16th and 17th centuries alone, we have more than 10,000 deeds that have been preserved by the Court of Aldermen of Liège. So of course, it's absolutely impossible to read them all and would be very boring as well because they all look alike. So I read and analyzed a representative sample of 1,159 deeds covering the whole period. So this allowed me to really observe the progression of provisions in those last wills and contracts across the whole period. And in total, I analyzed 690 last wills and 469 marriage contracts. So, as I hinted before, most of those documents, not all of them, were written by notaries. And so you see it because, they're all based on forms. So that's why I'm saying they all look a bit the same. It's because the notaries, they had this document telling them which clauses they had to recommend to clients depending on their personal situations. And also in the 17th century, we start seeing those provisions also in handbooks meant for notaries or future notaries, which also show us which were the most frequent provisions used and asked for by the notary's clients. So by crossing all of those sources together, I was able to draw a full picture, I hope a faithful one, of the legal position of women in Liège during that time period, considering both written law, but also legal practice, so notary practice more specifically. So now, delving into the topic matter of today, namely the legal status of married women, under Liège law at the time. So first, I would like to give you maybe a little bit of context about family law, more generally even the family structure, but also the conjugal model between the 16th and 17th century. Why? Because family historians often note that during this time, across those 2 centuries, the family structure went under important changes, more specifically 2 significant shifts, which I will describe now. So the first of those shifts concerned the family model as such. Family historians note that the family became gradually centered at the time on the nuclear family, so a bit more the model of family we still know of today. A nuclear family to the detriment of more distant kinship. So the historian in France, like Stéphane Maviel, for instance, described this shift as that from the kinship family to the what he calls the household family, namely whose members have in common that they share the same roots. They live together. This household family revolves around three central relationships. So the first relationship is that between the spouses. The second relationship is that between the parents and their children. And the last relationship is that between the masters, the husband and wife, and their servants, who generally live in the house with them. The family is a hierarchy with the master, father, and husband as its head. So each of these relationships was characterized by reciprocal rights and duty, including for the head of the family. The second important shift at the time is that following the Council of Trent on marriage of 1563, we witness a positive revaluation of the marital state within the Catholic Church, so a positive revaluation of matrimony in general. So this resulted from the affirmation during the Council of Trent in 1563, more specifically, of the sacramental state of matrimony, namely marriage as a way for both of the spouses to receive grace because they were married. So prior to this, especially in the 16th century, matrimony was rather seen as a last resort for people, both men and women, who were actually not strong enough to adopt a religious state which involved, of course, renouncing the pleasures and possessions of a secular life. So when we look at 16th century literature, for instance, we see that male celibacy, more specifically, is celebrated. And this literature also tends to convey kind of a genuine contempt, dismay towards marriage and also towards women because they were naturally associated with it.
Should not forget that the popes had children.
But after Trent, after 1563, we see that the conjugal model evolved towards a vision of the married couple in which friendship and conjugal affection and the duty to educate children together in accordance with the Catholic faith, but in the context of the Counter-Reform here, became paramount. So quite paradoxically, we could say, despite this positive revaluation of marriage and this focus on friendship within the couple, we see that the predominance of the man within the family, so the husband, the father, characterized in law by marital power, I will talk a lot about this today, remain largely unchallenged, all in all. So to tell you a bit more now about marriage at the time, so for theologians and canonists already since the Middle Ages, marriage was a sacrament, first of all, to which a contract was added. So this contract was formed by the exchange of consents between the future spouses. And as a contract, of course, a marriage was a source of mutual rights and obligations for the spouses. So Professor Dunk already discussed this a bit earlier, but when there was a violation on one of those duties by one of the spouses, this might result in the separation of the couple, separation which had to be ordered by the church court, so the ecclesiastical jurisdiction in Liège, the so-called officiality of Liège. So we can say that by attributing a mutual obligation on both the spouses, at least formally, because in practice, of course, it was not that easy, the canon law treated men and women within marriage equally, formally speaking at least. So to give you one of those examples of such mutual reciprocal duties of the spouses, it was the obligation for the spouses to share a roof, so to live together. Attached to this duty was another one that has been discussed a lot at the moment, especially in France. There's been a case law about it recently. What's the duty? The conjugal duty. So conjugal duty, which was the right of each spouse, so both man and woman, to demand sexual intercourse from their partner. So in practice, the obligation to live together meant for the husband the duty to provide a roof for his wife, And for the wife, it meant that she was not able to freely leave the house of her husband without a prior court permission, so even if the husband, for instance, was violent towards her. According to Jean-Henri de Manigat, so Jean-Henri de Manigat is the author of this Praxis Pastoralis written in the 17th century, basically a handbook to help priests and confessors to deal with the private matters of their parishioners. So according to Manigat, a wife could only leave the conjugal house unauthorized if her life was in danger. But even then, he adds later, she should quickly turn to a court, church court, of course, to regularize a situation. Why? Because otherwise she risks falling into a life of sin and to jeopardize her salvation. So we have a case from 1686 from the officiality of ULiège that shows us that at the time the officiality of Liège was not at all hesitant when it came to enforcing radically this duty of cohabitation of the spouses. So what is this case about? It's a case in which the officiality of Liège prosecuted and convicted a woman named Catherine Jaminon. Why? Because she had taken the liberty to leave her husband's house after discovering that she had married one of her cousins without dispensation. So even if the marriage was indeed very likely unlawful regarding canon law, the court ruled that Jaminon was not allowed to separate from her husband on her own, but should have seized the court to ask for a separation. So she was convicted and condemned. So this was to give you one example. Of course, the two other marital duties which still exist today in the Belgian Civil Code regarding marriage, the duty of fidelity that you mentioned earlier, so the prohibition of adultery, and the duty of mutual assistance. So this was to give you one example. Besides those mutual obligations of the spouses, marriage resulted in significant changes for the legal status of both the person of the woman, but also the assets that she brought with her to the marriage. So I will now subsequently address those two aspects of the matrimonial regime. In Liège, marital power, whether over the person of the wife or over the assets she brought to the marriage, was known under the name of main-plévy, which I evoked earlier. So, or dear Charles de Béon, writes everything in Latin. He refers to the main-plévy as the jus connubium of Liège, so basically its customary matrimonial regime. He also translates main-plévy from this vulgar French at the time in Liège into Latin, and he speaks of manus plicatae, so that's the translation he makes, literally the bent hand, an expression which seems to refer to the hand of the husband, of course, over the wife, alternatively controlling and protective. So regarding some personal effects of marriage for women, we can talk first, for example, of the fact that through marriage, women entered the family of their husband. This did not mean in the early modern period, as it could be the case, for instance, in Roman law in ancient times, did not mean that all legal bonds were broken between the wife and her family of origin. So what I could see from legal documents, for instance, is that the wife, at least for legal purposes, I'm not so sure for the rest, but at least for legal purposes, she preserves a maiden name, so the name of her father, and she can still inherit from her parents. So for women who were still under the guardianship of one of their parents when they got married, moreover, marriage meant definitive emancipation, we could say, from parental authority. However, for the wives, they immediately did not really change radically their situation, because otherwise stipulated in the marriage contract, and I will come back to that, women fell almost directly under the guardianship of their husband, so there was not really a lot of freedom in the meantime. So why do I say they fell almost directly under the guardianship of their husband? Because according to Liège's lawyer, the main-plévy only started over the consummation of the marriage and not the celebration of the marriage. So only after the spouses had had sexual intercourse for the first time. Moreover, a married woman adopted the social and legal status of her husband. So lawyer Sauet, who writes in the 18th century, explains that, for example, a woman of a poor condition, but who was raised by honest parents and who married into aristocracy, enjoyed a husband's title and all the privileges attached to this title. But yes, if following the passing of her spouse, she remarries a commoner this time, well, she loses both the title and the privileges of the first spouse, since she is forced to adopt the status of her new husband.
So it's better to remain a rich widow.
Absolutely, also for financial reasons. But the most striking, we could say, tangible manifestation of marital power at the time was unquestionably the wife's duty to obey a husband and its corollary, namely the husband's right to correct his wife if she misbehaved. So it's interesting, this right of correction of the husband, because when we look at 16th and 17th century sources, we do not see any mention of it. But this is true for Liège. It's also true for neighboring regions, as, for example, John Jellison very accurately observed already in 1962. So no mention of this right of correction of the husband in legal sources. So if we want to know more about it, what I did for the case of Liège is that I turned to the works of moralists. So people very concerned with the intimate private life of families and spouses. So for instance, in this work of 1608, churchman Jean-Baptiste Deglin tries to give couples some advice on how to settle what he refers to as domestic quarrels. So he establishes that the husband's right to correct his wife can only be exercised provided that three conditions are met. So the conditions are the following. First, of course, the wife must have committed a fault. She must have misbehaved. The second condition is that the right to correct the wife can only be exercised subsidiarily. So what he means by this is that when instructing her, making her see the error of her ways, and threatening her prove insufficient. And the last condition is that the correction must always be moderate. It's really with the aim to educate, not the aim to punish. So Deglin admonishes husbands who beat their wives, he says, out of passion or mere revenge, but also those who dare to do it in front of other members of the household, so the servants, for instance, the children. Why? Because he thinks this would risk undermining the authority and the respect that is due to the mistress of the house. Interestingly, Jean-Baptiste Deglin also takes care of reminding his readership that wives are not allowed to beat their husbands, as the right of correction derives directly from marital power, of which, by definition, wives are deprived. So finally, one of the main effects of marital power regarding the wife's personal status was the loss of her legal capacity upon marriage. So in Liège, this rule is set most notably in this Recueil des Points Marqués I mentioned earlier, Chapter 1, Article 4. So according to Pierre de Méan, following the marriage, a wife cannot, I quote, dispose of her property by will or otherwise contract, bind herself, or stand trial, except for a wrong delict in criminal proceedings, so if she's prosecuted by a criminal court. She cannot do any of those important legal transactions if she does not have her husband's authorization to do so. So, not being able to make your own last will, on this point, the custom of Liège is very severe, very strict. Why is it strict? Well, because for lawyers at the time, the last will is actually only considered as having effects, of course, after the person who drafted it is dead, namely in case of the wife at the time where the marital power has terminated already. So the other thing is that many foreign customs at the time allowed married women to draft their own wills. So Liège is really a bit of an exception, at least in the context of, we could say, the former Belgian regions. For example, in most customs in Flanders, but also in Brabant, here in Brussels, for instance, in Limburg and in Luxembourg, as Jellison underlined in 1962, married women could absolutely draft their own last will without...
Even in Luxembourg?
According to Jellison. I did not analyze every village, of course.
Normally, Luxembourg is seen as the most rural and remote part of the Austrian Low Countries.
Well, the Liège was worse, apparently. But there were some places in France, for instance, where there was a rule similar to that in Liège. So Liège was not completely exceptional in the customary law landscape, so to say, but for Belgium, quite special. And the severity of the law of Liège was known by the lawyers at the time. For example, Charles de Méan, him again, criticized the severity of the law of Liège on that point. And how does he criticize it? And I did not mention it earlier, but I placed the word jus commune in the title of my presentation. So jus commune, the Roman canon law tradition known by lawyers at the time. And Charles de Méan, of course, he studied in Leuven. He was well-versed in jus commune, so he refers to it very often when he discusses the law of Liège. And here, for instance, he notes that the law of Liège is contrary to the jus commune. And he uses this argument to criticize this incapacity of married women, which I found quite interesting. So why contrary to the jus commune? Because under Roman law, married women could draft the last will without the consent of their husband. But also canon law, of course, was, let's say, almost by definition, very, very favorable to last wills, and especially to last wills drafted by women, as it seems women were very generous towards church institutions, especially in the last will. So the church had an interest in women making their own wills. This is for the ability to draft contract, but more generally, we could say regarding this legal incapacity of wives, is that both legal scholarship and legal practice as well eventually managed to mitigate the strictness of Liège law in that regard. So first of all of Liège lawyers, for instance, agreed that it was enough that the husband was there in the room at the moment where his wife performed a legal transaction to consider that he consented to this act. So even if he was just standing there in a corner, remaining silent, it was considered that he agreed to what was happening. Moreover, Charles de Méan, him again, reports a court ruling of 1661, so we're already in the second half of the 17th century, a court ruling adopted by the Conseil Ordinaire of the Prince Bishop of Liège, which was the country's highest court after 1531. And so in this case, the Conseil Ordinaire ruled that the husband's consent to a legal transaction performed by his wife did not need to be given at the exact moment the transaction happened, but that it was sufficient that the consent, the authorization, intervened afterward, after the fact, meaning by means of ratification.
Who lived longer, the man or the woman?
At the time, apparently, already women. Yeah.
So you can wait until your husband dies and then...
Yeah, that's true. Yeah, it's really interesting because the demographic studies show that already at the time women lived longer despite all the potential complications during childbirth. But yeah, maybe also some more wars, and so the men maybe died more quickly like this. So interestingly, in this case of the Conseil Ordinaire, Charles de Méan once again refers to debates taking place among the jus communis lawyers of the period, and in this case, more specifically, it refers to the words of those two lawyers. So we have on the left that you maybe already know, Petrus Peccius, who was a professor in Leuven and a member of the Great Council of Mechelen. And to the right, you have the French lawyer André Tiracolus. So Charles de Méan confronts the two opinions of those two men. And first, he presents the opinion of Peccius, and he explains that Peccius submitted that marital consent had to be first expressly given, so he would not agree with the fact that it was enough if the husband stood silent while the wife was acting. But also, Peccius was of the opinion that the legal transaction, that the consent, of the husband had to take place exactly at the moment when the wife acted. Why? Because only the auctoritas, again a Roman law reference, of course, of the husband could confer full legal capacity on the wife. So de Méan stresses that in the case of 1661, however, the Liège court did not follow this opinion of Peccius, but rather followed the opinion of Tiraco. So Tiraco had argued that since the obligation to give consent, this authorization, existed to protect the interest of the husband and not the interest of the wife, then the husband could decide to ratify the act afterward if he desired to do so, because it was his interests that were at stake and not those of the wife. So to conclude with the wife's legal incapacity regime, it's important to stress that there were several exceptions to this regime recognized by customary law itself. So to give you a few examples, there are more, but in Liège there was the possibility to derogate from the main levy regime by means of a marriage contract. The capacity was also recognized to the wife, a form of legal capacity, when she was spending her husband's money to feed and to clothe the family. And finally, we can also mention, I think also quite discussed in literature, this one, the legal capacity recognized to wives who publicly worked as traders, so as Americans, but regarding business transactions only. So very.
What is called the koopwet in.
Exactly. Yeah, absolutely. Mm-hmm. So this regime of the legal incapacity of wives was known in Liège. You have to know it was actually rather common in those parts of Europe, with only a few variations from one custom to the other, like the example of the incapacity of women, of married women, to make their last will shows in the case of Liège. It is actually more in its financial aspect that the matrimonial regime of the main levy in Liège distinguishes the law of Liège from the law of the neighboring countries at the time. So through marriage, and unless again otherwise stipulated, so you could derogate from this regime, husbands acquired an ownership title over all their wives' assets, both movable property and immovable property, through marriage. So regarding immovable property, there was one exception for one category of real estate property, namely the case of the so-called alleux, so basically some real land, so neither feudal property or censal property. So this meant that the husband, during marriage, could absolutely alienate the possessions of his wife if he wished to do so, and the wife could not oppose her husband. So, of course, it's not difficult to perceive the potential danger of a system like that, because if the husband is a bad manager, for instance, or if he invests all of his wife's assets instead of his own in risky endeavors, of course, he could potentially, virtually, dispossess his wife entirely. This state of the law led certain amounts of individuals to restrict the husband's prerogatives by means, you will have guessed by now, I think, of marriage contracts. So in my sample of documents, I identified that around 28% of each of my samples, so less than 1/3 of the documents I've read, provide for limitations of the husband's power, either to dispose of his wife's assets or parts of those assets, and or provisions that aim to preserve the wife's legal capacity regarding usually certain assets that she brings to the marriage. Those clauses, those provisions, I have to tell you, was really a struggle for me to try to categorize them and classify them, because even if they have similar purposes, they tended to come in very different shapes, actually. So it was very hard to draft an actual taxonomy, so to say, for them. But that's for legal practice, so not really practice. The practical issues, which I a bit hinted right now, brought about by the implementation of the main levy regime in practice, eventually led to a progressive restriction of marital powers, so going above simply a notary practice that was trying to restrict the husband's prerogative. So we see this already in the 17th century, but even most notably at the very beginning, in the first quarter of the 18th century. So what happened there, that's interesting to note, is that in the first quarter of the 18th century in Liège, there was an attempt at reforming the customary law of Liège. And the lawyers in charge, we see this in the archived documents documenting this event, the lawyers in charge of the reform proposed putting an end to the main levy regime in its financial aspect only. So the idea was to change the rule and decide that now the husband had to require the consent of his wife anytime he wanted to dispose of her immovable property. So this system was, we're not going to details here, but was probably inspired by the Roman law dotal regime, and very likely also inspired by examples from neighboring countries, especially the Southern Netherlands, who had more a community regime. So this reform never entered into force in Liège, which means that the main-lévy stayed as it was before until the end of the 18th century, never changed. But what I thought very interesting about this historical episode is that it shows that even already at the time, the negative effects of marital power for wives and probably more generally for the general financial welfare of families led some lawyers to seriously consider restricting it and replacing it with a model of management within the family much more equal between the spouses, at least regarding the assets of the family. Which is very interesting, especially when one thinks that a century later, the Code Napoleon in France is going to be a big drawback for women in that sense. So, as you understood, I hope so far, this main-lévy regime for women during marriage, very disadvantageous, right? However, in case the husband passed away, and if the couple did not have any children, or if they all died in the meantime, there was a huge payback, we could say, for the widow. So, indeed, in such case, the widow was entitled to ownership rights over all the spouse's assets, except for one category of assets of the husband, namely the so-called fiefs typos. So to put it in a nutshell, these were ancient family fiefs of the husband. The wife only had a right of usufruct over them, not ownership rights. So this meant that at this point, the husband assets belonged to the widow, and Liège lawyers refer to this inheritance right, this very important inheritance right of the widow, as her droit de main-lévy. So if the widow remarried afterwards, she took all the assets of her husband with her into the family of the new husband. So hence the interest of marrying very rich widows. Rich widows were actually a very rare currency, a good currency, we could say, on the matrimonial market. And this often caused disputes between the widow and the legitimate heirs of their deceased husband, so the family of the first husband, disputes which I think would be worth investigating further. So, in the eyes of Charles de Méan, this droit de main-lévy of the widow was actually not crazy important, it was fully justified. So what does he explain about this? He says that the droit de main-lévy actually is nothing more than the rightful compensation for the wife's loss of her property endured during marriage. In that regard, it is actually noteworthy to note that de Méan also explains that women who set aside the main-lévy regime in their marriage contract are not entitled to the droit de main-lévy, not entitled to this compensation, to this important inheritance right. So this was a very quick and broad overview of the legal status of women as wives during marriage. And I will now, to finish, briefly discuss the legal relationship between women and their children. So today I will only focus on the case of legitimate children, so born within wedlock. I will not talk about the very specific situation of natural children and their mothers. Also another complicated topic. So the first thing to know about that is that during marriage, the father was the only guardian of his children. So when we look at 16th century sources, the father is said to have the puissance, so literally the power over his children. So puissance is a clear reference to the potestas of the Roman father. It's not surprising to see that in 16th century sources. We also see a reference to the Mambourni of the father. Oh, I think there was, I don't remember the exact word in ancient Flemish, but there's a similar word. Exactly. A word of apparently Frank origin. So this meant that while the father lived, the mother seemingly did not enjoy any guardianship rights over her own children. So there might be a slight nuance to that brought forward by Sauet, so right in the 18th century, which is that mothers who shared in the father's duty to educate the children were allowed to beat them only if they misbehave, so only in this purpose of education. Yeah.
And
All
also
time.
the little dog.
Maybe also the little dog. I don't know if you could beat the children and get the dog, not an issue. So the children were born to a duty of respect and obedience, not only towards their father, but also towards their mother. Most importantly, when the father died, guardianship rights in Liège automatically fell to the mother. So what's interesting when looking at the sources is that, for example, records of the Liège alderman also speak, when it comes to the mother, of the puissance maternelle. So this reference to the potestas, which would be very surprising to Roman lawyers. Also talk of Montbruni, of the mother, and also talk of tutelle. So tutelle is literally the French word for guardian, of the mother. In some private deeds, we also see notaries refer to the guardian mother as the Montbrunesse, so literally the female Montbrun of her children. So here again, Charles de Méan, well-versed in jus commune, as we've seen so far, cannot help but compare the situation of mothers in ancient Rome and mothers in Liège in the early modern era. So the first thing he does here is that he reminds his readership that in Rome, for a very long time, mothers, women, were not allowed to be appointed as guardians, not even of their own children. So why was that? Because guardianship was considered by the Romans as a public office, a public mandate, and women, by reason of their sex, were excluded from all public offices. Why? Because they were regarded as officia virilae, so basically mandates that could only be occupied by men.
That is the same argument that the Court of Cassation used against Marie Popin.
Oh, well,
being a lawyer is un office viril, and they went back to Roman law. So women are too emotional, etc. They can't do this. Whereas nowadays, the majority of lawyers and judges
are women. Mm-hmm. Yeah, this argument has a very long history. We see it across all time periods. So consequently, in Roman times, when the father passed away, children were placed under the guardianship of a male relative and not the guardianship of their mother. Things, however, and so I'm still like de Méan keeps explaining, keeps accounting this history. De Méan explains that later, guardianship rights upon the father's passing were recognized to both the mother, and in the absence of the mother, also to the grandmother of the children. And indeed, as we know, this legal change intervened around the 2nd century after Christ. And so at first, Roman mothers could only become their children's guardian, provided they received permission from the emperor. But from 390 after Christ onwards, this imperial consent was no longer mandatory. But the mother could still be excluded from guardianship right if the father, before dying, had appointed someone else, a man, as a guardian in his last will. Moreover, in Rome, if the mother remarried, she was excluded from guardianship rights over her children. And here de Méan further explains that it is because the Romans feared her loyalty could be divided between the potentially conflicting interests of a husband, a new husband, and the interests of her children. Very interestingly, Méan concludes this historical account by the following observation, and this is my translation of it. He says that guardianship rights of mothers were never indefinite or universal, but rather depended on specific cases and rules. And from this, he comes back to his present time, so early modern Liège, to explain that in Liège, the mother was automatically the guardian of her children after the passing of her husband. He then affirms that the extent, the nature of the mother's attribution over her children is equal to that of the father, because he refers to the mother's guardianship rights as a substitute for those of the father. So for him, it's the same power that the mother exercises. So furthermore, in Liège, if the mother remarried, she was not excluded from all guardianship rights, unlike the Roman mother. So from the sources, from what I could gather from the sources, it appears that the mother was placed in a form of, this is me calling this like that, a form of joint guardianship, we could say, of her own children with a new husband. And actually the reason for that is quite easy to understand regarding everything I explained earlier, is that, of course, the mother, when she remarried, well, she and all of her assets, well, were placed under the main privy, the marital power of the new husband. And consequently, the husband managed the property of the whole family, so including his wife and her children. But Liège law makes it clear that the new husband's ability was limited to the assets of the children of his wife that were still underage, so meaning before 1572, 17, 18 years old, and after that, 25 years old for both sexes. Besides, and according to Sauet, the remarried mother in Liège still enjoyed the right to educate her own children. So that means that the stepfather did not have, was therefore not left to appreciate what was good for the education of the children of his wife. Alone, the mother could absolutely decide as well in that regard. Sauet also expresses that Liège law, I quote him, functions in that regard differently from Roman law. So he also makes this comparison, of course. Elsewhere in his work, Sauet also states that a mother, even one that remarried, is still the legitimate guardian of her children, as she retains the right to appoint for them the guardian of her own choice in her last will. Mm-hmm. So a century earlier, Charles de Méan expressed a similar opinion, explaining that the authority of the stepfather over the children of his wife could never be, he says, absolute. So he gives two arguments to explain this stance. The first one, because since they are not the stepfather's children, there is, according to de Méan, always a risk that the stepfather will only regard them as strangers and neglect them. The second argument he brings forward is that it cannot be expected from a mother that she's going to give up her, I quote, maternal feelings so easily, and which is why she should always have a say in the education, for example, of her own children.
And that is then the Tridentine elements, namely that after the Council of Trent, marriage is seen as friendship and affection more than before.
As well, absolutely, yeah. But despite, and I will finish with that, despite those affirmations by the Liège lawyer that this maternal authority, this authority of the mother, was of the same nature and the same extent as that of the father while he lived, well, in practice, of course, things were a bit more nuanced and complex than that. Why? Well, first, because, of course, the situation of the widowed mother was very different from the situation of the father during the marriage. The widow, as we also discussed a bit earlier, found herself in the position of the new head of the household. So she had to manage her husband's business, sometimes with very fruitfully, and sometimes also having the responsibility to continue the trade of the husband. So she recovered a form of legal independence because she had to be able to manage the family and the family assets, but she was also burdened, and sometimes for women for the first time in their life, to burdened with the responsibility of caring for their whole family. This is why, before the death of the husband, and this is something we can study through last wills, either the husband alone in his own last will, but sometimes as well the spouses together, so in a joint last will, could appoint one or more guardians. So here, in the case of Liège at least, it's very important to stress that those guardians, they're not guardians of the widow herself, the guardians of the children of the spouses. So they were tasked with two main missions. The first one, they had to assist the widow and help her in managing the business of the family. But also, second mission, they had to make sure that she did not do anything that could deprive her children from their inheritance. So there was also this aspect more of helping, assisting, but also a bit this supervision and control over her action. So whether this appointed guardian or the appointed guardians were there more to fulfill one or the second one of those two missions was probably have depending on each case and the circumstances of their appointment. In all likelihood, the widow's room of margin, so to say, of maneuver must have been much greater when she had participated in appointing the guardian than with the husband when the husband on his own had decided for a guardian to control his wife, maybe because he did not trust her or her ability to deal with the family matters. This concludes my quite quick and brief overview of the legal situation of women, married women in early modern Liège. So I thank you very much for your attention, and I would be very happy to hear your feedback and questions.
Thank you very much. Sorry for the noise. Apparently somebody outside is yelling at the MLS. We can't really change that. I will also make a small addition. I forgot to mention the co-supervisor of our speaker's PhD, our most distinguished colleague, Ben de Kok from Louvain and Liège, who is appointed at both universities.